Chapter 7. Accounting for Income and Principal. Key exam issues. In any question involving principal income accounting issues, the first thing you should do is analyze the expressed or implied trust terms, as these prevail over the general statutory or common law principles. Next, consider those general principles. Also be alert to possible applications of the trustee's duty of impartiality in balancing the almost inherently competing interests of income and remainder beneficiaries. Particular problem areas to watch for include I. The handling of income from transition periods, i.e., income during estate administration or income of periods within which the testator or life beneficiary died, in terms of both what the trust is entitled to receive and how those receipts are allocated between income and principal. II. Extraordinary stock dividends or splits, and III. Underproductive or overproductive, i.e., wasting property problems. Also watch for distinctions between ordinary expenses and extraordinary or capital expenditures, and for the possibilities of apportionment or depreciation amortization treatment of the latter. A. Introduction. 1. General nature of the principal income problem. A. Successive interests 847. In the typical trust situation, interests are generally divided between one or more income beneficiaries, usually for life or sometimes for other periods, and one or more remainder beneficiaries, whose eventual rights are in trust principal. Obviously, in most trusts, the economic rights of these two types of beneficiaries can conflict. 1. Classification of funds 848. The resolution of conflicting claims among beneficiaries often turns on the classification of funds in the hands of the trustee, either as income, the net income usually being payable currently to the life beneficiary, or as principal, generally to be retained in the trust estate for future interest holders. Thus, it is essential to classify receipts and disbursements so that they may be credited or barged to or apportioned between income and principal accounts. B. Discretionary benefits 849. The importance of accounting issues and rules is affected by the nature of the successive rights of the various beneficiaries, depending on whether trust accounting income may determine the rights of one or more of the beneficiaries. 1. Discretionary power over distributions 850. The seriousness of the problem is lessened but not eliminated where, as is often the case, a life income beneficiary may receive principal in the discretion of the trustee who holds a power of invasion. The maximum rights of the beneficiary are not confined to income, but the minimum rights are set by the income account. The problem, however, is not present in a trust that is, or for so long as it is wholly discretionary, with or without a standard to guide the trustee's exercise of discretion over distributions, e.g., a trust to pay L such amounts of income or principal, or both as necessary for L's support, provided the discretionary benefit is limited to income. 2. Annuity or unitrust interests 851. Nor does the distinction between income and principal matter for strict, i.e., without an income ceiling or floor annuity trust interests specified, even indexed, dollar amount to be paid periodically, or unitrust interests paying a specified percentage of principal, usually valued annually. 2. Sources and priority of accounting rules. A. Trust terms 852. Like most questions of trust administration, unless there is a controlling public policy restricting the settler's freedom, the terms of the trust govern trust principal income accounting questions whenever the matter is covered expressly or by an intention that can be found by construction of the trust provisions, i.e., implied. B. Legally implied rules. 1. State Law 853. If a particular accounting issue is not covered by the terms of the trust, it will be resolved in accordance with the applicable state law, usually by the terms of the state's principal and income statute, which all states, at long last, have in one form or another. Many still have a version of the revised Uniform Principal and Income Act 1962 Act, and a rapidly growing number have adopted a newly revised Uniform Principal and Income Act 1997 Act. Gaps in statutes may be filled perhaps under statutory mandate by common law principles or resort to generally accepted accounting principles. 2. Accounting Rules 854. The specific rules of trust accounting often differ from general accounting principles because the trust law is influenced by special factors. Students trained in accounting will sometimes be quite surprised at the trust law's strange lack of respect for normal financial concepts of net income. For example, there is a tendency for some types of issues to favor income beneficiaries reflecting the settler's probable intent, such beneficiaries usually being closest to the settler. There will be a tendency in other situations to avoid a forced income distribution of properties or funds likely to be important to maintaining a properly functioning trust estate. Examples of an income bias include apportionment of certain routine expenses between income and principal and a lesser inclination than in other accounting fields to charge depreciation against income. An example of the less frequently occurring principal bias is the usual retention of stock dividends entirely as principal without acknowledging underlying differences in the practices of various corporations. These MWIRs are discussed below. A. Note: these preferences or biases are not so much applied by courts on a case-by-case basis as they are built into the design of specific rules for application generally to a particular type of recurring issue. C. Trustee Discretion 855. By the terms of a trust, the trustee may be given private rule-making authority in principal income matters. What the settler intended is a matter of interpretation of the trust provision. A settler, of course, should attempt to be clear about the scope and nature of the discretion. The power may be interpreted to allow the trustee to override other trust provisions or legally implied rules if in the trustee's judgment it appears appropriate to do so, e.g., in the trustee's judgment the provisions or rules appear unfair or unduly harsh as applied to the particular trust and situation, especially in light of the trustee's chosen investment program, or Roman II to be used only where the instrument or the law does not provide clearly or at all for a particular matter. 1. Broad construction of trustees' authority 856. Many courts have construed the trustee's authority broadly under such powers Dumaine v. Dumaine, 16 NE 2D 625 Mass. 1938. Even on this issue courts not only differ, but a given court may waver from time to time or based on tedious distinction. 2. Note: within the scope of the discretionary power, the trustee's decision is usually controlling as long as it is made reasonably and in good faith. D. Impartiality 857. In general, as in other aspects of trust administration, the law is designed and the trustee's accounting judgments are expected to reflect an overall fiduciary duty of fairness and impartiality to all beneficiaries, while at the same time respecting expressed or implied purposes, preferences, and intentions of a particular settler. 1. Adjustment Power 858. The trustee's duty to make trust property reasonably productive of income while observing the duty of impartiality may inhibit the trustee's efforts to invest optimally on a total return basis. Thus, the 1997 Act prompted by the modern prudent investor rule allows a trustee to compensate a beneficiary whose interest suffers, usually the income beneficiary, when the trustee undertakes an investment program that has a greater total return expectation, emphasizing, e.g., stocks heavily over bonds, intended for the long-term benefit of all. But that does not fulfill the usual dictates of the duty of impartiality. To satisfy those requirements, the trustee may exercise an adjustment power. 1997 Act 104. Increasingly, statutes are adding a unitrust option C supra 851 as a proxy for the income right if the trustee so elects. Compare Rest. 3D 79 CMT. A use of common law power duty of equitable adjustment. Exam tip. If you encounter an exam question that involves principal income accounting issues, remember that the first thing you should do is analyze the expressed and implied terms of the trust, which prevail over the general statutory or common law principles. Next, you should determine whether there is a statute that governs the particular issues. Keep in mind that a court may broadly construe a trustee's discretionary power over accounting matters. Finally, remember that, under the 1997 Act, if a trustee determines that by following the trust terms or statutory rules, she is unable to comply with her duty to administer the trust impartially, the trustee may make adjustments between principal and income to the extent necessary. 8. Specific rules of trust principal income accounting. 1. Allocation rules are Default Rules 859. Where the trust instrument is silent and the trustee is not expressly given accounting discretion, the rules for allocating benefits and burdens between income and remainder beneficiaries are as follows. 2. Allocation of benefits, essentially Receipts 860. Trust income is payable to the income beneficiary, while trust capital belongs to the remainder beneficiaries and is invested for any future income beneficiaries. Trust income includes all ordinary receipts from use or investment of the trust property. In this category fall rents, dividends, interest, etc. Extraordinary receipts are generally trust capital unless they are in some manner to be apportioned. This includes proceeds from the sale or exchange of assets, settlement of most claims for injury to trust property, etc. A. When right to income commences 861. The income beneficiary is entitled to the net income from the date of creation of an inter vivas trust, or from the date of death in the case of a testamentary trust, even though there is an intervening period of administration of the senior's estate. Rest. 2D 234. B. Earnings of testamentary trusts during estate administration 862. As indicated, the earnings on the trust corpus during administration of the decedent's estate are generally allocable to the income account from the testator seniors. Date of death, even though not payable, of course, until the trustee receives distribution of the trust funds. 1. Distinguish non-trust gifts 863. If no trust is involved, the amount of payment and date from which it is computed would depend on whether the gift was a general or specific one. The usual rule is that the legatee of a specific bequest, e.g., my 1,000 shares of U.S. Steel, is entitled to actual earnings on the funds or property bequeathed from the date of death, whereas the legatee of a general dollar amount, or pecuniary bequest, e.g., $10,000 is entitled only to the statutory rate of interest, not necessarily the actual earnings on the funds involved commencing 1 year after the date of death. See Will's summary. 2. Rule where trust involved. A. General Rule 864. In trust accounting, the general rule is that the income beneficiary is entitled to all earnings on the trust estate from the date of death. What these earnings are, however, may follow the will's rule above, or perhaps more often any interest payable to the trust may commence at the date of the testator's death. Example: if testator devises perpleaker to brother in trust, income to child, child is entitled to perpleaker's actual net earnings from the time of testator's death. Standard result, with or without the statute. B. Statutory View 865. The 1962 and 1997 Acts provide that the income beneficiary of a pecuniary amount bequeathed in trust is entitled to the net earnings after deducting net income of specific devises and bequests on a portion of the estate equal to the pecuniary amount from the date of death. 1962 Act 5B2 and C. 1997 Act 2013. 4. Example: if testator bequeaths $100,000 outright to brother, brother has no right to the actual earnings on a corresponding $100,000 portion of the estate during the period of administration. Brother's only right is to the statutory rate of interest on that sum, commencing 1 year after the date of death. On the other hand, if testator bequeaths the $100,000 to brother in trust to pay the income to child for life, remainder to grandchild, child is entitled to the actual net earnings after deductions on a portion of the estate, equal to $100,000 from the date of testator's death. 1. Rationale. The apparent rationale is that where the testator makes a gift of the income of certain property or funds in trust, it is indicative of her intent that the gift should be effective to provide for the life beneficiary from the date of her death. In Re Stanfield's estate, 135 NY, 292 1892. 2. Note: not all statutes follow the above rule. Some statutes in some cases provide for statutory interest from the date of death, or follow the non-trust pecuniary bequest rule also for trust's interest from 1 year after the date of death. 3. Residuary trust earnings of other estate properties 866. Note that there is a conflict of authorities where there are earnings during probate that are derived from assets that do not ultimately become part of the trust estate. Example: testator creates a trust of the residue of her estate, and various assets are sold and used during probate to pay off pecuniary bequests, taxes, administration expenses, and claims against the estate. The income from such assets clearly becomes part of the trust estate. It falls into the residue. Should the trustee regard such receipts as trust income or as capital? A. Majority view income 867. The majority view is that such receipts are income. This is the so-called Massachusetts rule, and is adopted in Section 5 of the 1962 Act and continued in the 1997 Act. B. Minority view principle 868. There is some authority contra that limits the income beneficiary to income attributable to the assets that come into the trust. Under this view, the earnings from any other source, i.e., the earnings here in question, are entirely allocable to the trust corpus. Baldwin v. United States 214 F. Sup. 16D. Mo. 1962. C. Minority view apportionment 869. Still other cases apportion the earnings between the income and principal accounts based on a formula like that applied to apportion receipts from the sale of unproductive property. See Infra 892. However, this rule, although often said to be a sound answer, is less popular than the other rules because of its supposed complexity. C. Timing of receipts apportionment of income as between successive beneficiaries 870. A frequent issue between successive beneficiaries is whether income received after the death of the testator or a life beneficiary should be allocated on the basis of when it was received or on the basis of when it accrued. Example: on the death of life beneficiary B, income becomes payable to another income beneficiary. C. Do income items received by the trust after B's death, but accrued during her lifetime, belong to B's estate or to C? 1. Common Law Rule No Apportionment 871. At common law, the income is usually allocable to whomever was the income beneficiary at the time the trustee received the income, regardless of when the right to such income accrued. Example: if annual rents were paid to the trustee on January 1, covering use of trust property during the preceding years, and C had become the income beneficiary on December 31, C would be entitled to such rents. B's estate would get nothing. Fraser v. First National Bank, 178 So. 441 LA, 1938. A. Exception apportionment of interest income 872. Unlike other types of income, interest is deemed earned on a day-to-day basis and hence is allocable ratably to whomever held the right to the interest income as it accrued. This is an exception to the general common law rule against apportionment. Dexter v. Phillips, 121 Mass. 178 1D 876. WWA. Annotation: apportionment of L income where right to income commences or ends during accrual period. 126 ALR. 12/1940. 2. General Statutory View Apportionment 873. Under most statutes, all income except dividends is apportionable in these situations. 3. Minority Statutory View 874. Under some statutes, income generally is not apportioned. However, some distinctions are drawn in several of these statutes between testamentary and inter vivos trusts. A. Payable before death 875. Monies received by a testamentary trust are regarded as principal if they were payable before the decedent's death. B. Certain installment or periodic payments 876. Even though not payable until after death, certain installment payments, e.g., promissory note payments received by a testamentary trust that cover a period both before and after the settler's death are apportioned, i.e., the portion of the payment that accrued before the date of death is principal and the balance is income. This approach may apply to certain other periodic payments under some statutes. C. Other situations 877. Otherwise, receipts to a trust testamentary or inter vivos are treated entirely as income, i.e., no apportionment, even though earned, ac accrued, or otherwise payable before the trust was created. Example: interest accruing on a bank deposit is income if the trust exists when the deposit is credited, even though it was earned in part before the deposit was transferred into the trust. D. Special rules governing dividends 878. Difficult problems arise in connection with the dividends received by a trust from corporate stock, i.e., determining whether a particular corporate distribution is trust income or trust principal. 1. Ordinary cash dividends 879. Ordinary cash dividends are easy. They are income. 2. Extraordinary dividends cash or stock 880. There are several important issues about whether extraordinary dividends are income or principal. A cash dividend is extraordinary either because of its size or circumstances. All stock dividends are extraordinary. A. Massachusetts Rule Modern Statutory View 881. Whether an extraordinary dividend is income or principal depends primarily on whether its distribution payment to the income beneficiary would impair the trust's proportionate interest in the declaring corporation. Minot v. Payne, 120 NE, 167 Mass., 1918, Rest, 2D 236. 1. Stock dividends 882. Thus, in what is by far the most frequent application of this principle, dividends payable in stock of the declaring corporation, whether technically a dividend or a split, are always allocable to principal. 2. Extraordinary dividends in cash or other property 883. Extraordinary cash dividends or distributions of other property, including stock of another corporation, are usually, by statute, e.g., 1962 Act 6, 1997 Act 401, allocable to principal, even though in these situations the trust would normally retain the same percentage of ownership in the declaring corporation. Allocation to principal is appropriate because such distributions are usually received by trustees by reason of total or partial liquidations as defined in the statutes, with some variations in detail, or by the trustee's election under an option to receive either cash or shares of the declaring corporation. In some exceptional distributions of these types, the cash dividend may be income. See Rest, 2D 236. 3. Special Rule for Mutual Funds 884. Cash or other property received by a trust is allocated to principal if paid to the trustee by reason of capital gains or liquidation distributions received by mutual funds and other regulated investment companies in which the trust owns shares. Cash distributions by a mutual fund representing its ordinary dividends or interest are income to the trust. B. Pennsylvania Rule One-Time Minority View 885. A probably extinct minority view was that extraordinary dividends, whether paid in stock or cash, were principal to the extent that they reduced the book value of the shares below what it was when the stock was acquired by the trust. Otherwise, they were income, i.e., the trustee had to determine what portion of the extraordinary dividends represented surplus, i.e., earnings accumulated since the trust acquired those shares, with only that portion being allocable to the income beneficiary. The rationale was that the remainder beneficiary was entitled to have the intact value of the shares retained. Earp's Appeal, 28 Pa. 368 1 in 857. 3. Other corporate distributions 886. The same common law and statutory rules supra 883 allocate corporate distributions of stock rights and options and proceeds of their sale to principal. Exam tip. An easy way to remember whether distributions received from a corporation are allocated to income or principal under the modern view is that money received from a corporation, e.g., cash dividends, is characterized as income unless the distribution was quite large or received in partial or total liquidation of the corporation. And all property other than money received from a corporation, e.g., stock dividends, is characterized as principal. Allocation of proceeds from sale of trust assets. 1. Sales in general 887. All proceeds from the sale of most trust assets, but see infra 890-895, are principal, i.e., become part of the trust capital account. Effect 888. Under ordinary circumstances, only the principal account is credited with profits and charged with losses realized on the sale. Income elements 889. Gains on the sale of investments and other capital assets go to trust corpus even when they represent increases in value that eventually would have been realized and distributed to the income beneficiary as rents, royalties, dividends, etc., had the trustee retained the investment. Hirsch v. Hirsch, 116 SE2D 611 GA, 1960. 2. Underproductive property allocation of proceeds of delayed sale 18901, except for a special provision on marital deduction trusts CLRC. 2056. The rule on unproductive or underproductive property below is expressly abandoned in the 1997 Act as being inappropriate when income productivity is based on the trust portfolio as a whole and in light of the trustee's adjustment power under Section 104 of the Act. Over time, judicial decisions and amendments to other statutes can be expected to follow. Background trustee's duty to sell 891. A trustee is often under a duty to sell property that becomes unproductive or underproductive. Rest. 2D 241 under the 1962 Act. Property that annually yields less than 1% of its original appraised value or market cost is classified as unproductive. 1962 Act 12. Apportionment Rule 892. If a trustee finds it necessary to hold such property and its sale is delayed, she is to apportion the net proceeds of the sale between income and principal in such a way as, in effect, to give the income beneficiary an amount representing and reasonably like Y to approximate what he would have received had the property been sold as soon as the duty to sell arose, usually, under the 1962 Act, the first year the property earned less than 1% of its value, and had the proceeds then been invested in normally productive property. 1. Note: this rule applies whether the sale produces more or less than the cost or appraised value of the property. 2. Interest 893. In calculating the income that would have been earned on normally productive property, the common law looks to the going rate of return on trust investments in the community. Under the 1962 Act, however, the rate is stipulated at 5%. 1962 Act 12b. 3. Bond or note in default 894. Where the property involved is a bond or note that is in default, a dubious version of the common law rule might give the income beneficiary the interest rate agreed upon in the bond or note if that is higher than what the average trust investment would have earned. Rest. 2D 241. C. Illustration Apportionment Computation 895. The trustee was unable to sell until 5 years after the investment became unproductive and then received $250,000 net for it. Assuming a 5% average trust yield totaling 25% for the period 5% x 5 years, without compounding, the principal is ascertained by dividing $250,000 by 125 for the proceeds represent 100% principal plus its supposed earnings of 25%. Result: allocate $200,000 to principal and the rest $50,000 to income. F. Treatment of wasting assets 896. A wasting asset is any property that is depletable or perishable through use, e.g., timber, minerals, patents, annuities, copyrights, etc. 1. Bequest or devise of properties, generally 897. Where a wasting asset becomes part of the trust estate under general terms in the settlers will, e.g., all my estate or the residue of my estate, it has typically been presumed that the settler intended both the income beneficiary and remainder beneficiary to enjoy the benefit of the property. Hence, the trustee must either provide for amortization, deduct from income, and set up a reserve, or sell the property and invest in permanent securities. Howe v. Earl of Dartmouth, 32 Eng. Rep. 56 1E 802, Rest. 2D 239. 2. Specific testamentary or inter vivos gifts 898. On the other hand, where the settler makes a specific gift, during life or by will, of a wasting asset to the trust, e.g., my oil well to T in trust for B for life, remainder to C, the income beneficiary has typically been allowed to receive all receipts, on the rationale that this is what the settler must have intended in making a gift of the income from an asset that is depletable. Ph. Vartanian. Annotation. Right as between life tenant and remainder man in respect of property, estates, or securities of a wasting, consumable, or perishable nature. 77 ALR. 778 1932. 3. Open Mines Doctrine 899. Where mines have been opened prior to creation of the trust, all the receipts therefrom are treated as income payable to the life beneficiary. A. Distinguish mines opened after creation of Trust 900. If, however, the mines are opened by the trustee after the trust is created, the receipts have been treated as principal, which the trustee must invest, the investment income being payable to the life beneficiary. In Re Knox's estate, 195A, 28 Pa, 1937. B. Criticism. According to its critics, this distinction gives the life beneficiary either too much or too little, and the principle of amortization applied in other wasting asset cases above should apply equally to mining operations. Exam tip. Remember that receipts generated by mines that were open prior to the trust's creation are treated as income, while receipts generated by mines that were open after the trust's creation are treated as principal, which must be invested by the trustee, and the receipts generated by such investments belong to the income beneficiary. 4. Uniform Act 901. Under the 1962 Act, payments that represent merely the rental of a wasting asset are allocable to the income beneficiary, whereas production payments and the like are subject to apportionment. 1962 Act 9, the 1997 Act provides for apportionment, generally 10% income, 90% principal of deferred compensation, liquidating asset distributions, and oil and gas receipts, and a more complicated set of rules for timber. 1997 Act 421-424. These rules have been viewed by some as unsatisfactory, especially for retirement benefits, and are being amended in a growing number of states. G. Bond premium and discount 902. Bonds often sell at a premium or discount as a means of adjusting the bond's contractual rate of interest to the market rate at the time of sale. If the bond's rate is higher than the market rate, it will be sold at a premium. If it is lower than the market rate, the bond will be sold at a discount. Some bonds bear no interest, but in lieu thereof sell only at a larger discount, reflecting the full amount of interest to be earned upon redemption. 1. Non-interest-bearing bonds 903. In the case of non-interest-bearing bonds, the increment on sale or redemption traditionally has belonged to income. That same result may be achieved by anticipating the eventual profit on redemption or sale and by making appropriate periodic payments from cash flowing into the principal account. 1962 Act 7A and C Rest. 2D 233 CMT. D. But see 1997 Act 412B. Payment received on zero-coupon bonds and the like is generally principal relying on the adjustment power, Supra 858, to to cope with any resulting overall unfairness to the income beneficiary. 2. Other cases interest-bearing bonds. A. Premium 904. The restatement rule has allowed but has not required amortization of premium by retention of excess interest in the principal account to repay that account for the loss on redemption unless not to amortize will be unfair in light of the trust investments as a whole. Rest. 2D 239 CMT. F. B. Discount 905. That rule provides that discount cannot be amortized to increase the income payments out of anticipated profit to principal on redemption prior to the sale or redemption of the bond. But then the proceeds may or may not be apportioned as fairness dictates. Rest. 2D 239 CMT. B. C. Uniform Act 906. Legislation in some other states precludes amortization of either premium or discount on bonds, except on non-interest-bearing bonds. See Supra. 903. 1962 Act 7A. This rule effectively casts the responsibility for impartiality upon the trustees' balanced investment decisions. Easier said than done. 3. Allocation of burdens, essentially expenditures. 907. The general rule is that the trustee should pay the ordinary, current expenses of trust administration out of trust income, whereas expenses that are extraordinary or solely beneficial to the remainder beneficiaries should be paid from the capital account. Generally, the cost of keeping the trust property productive and secure is borne by the income account. Likewise, the income account is chargeable with all expenses of trust operation that go to the production or collection of income, while the principal account is chargeable with expenses that go to the improvement or preservation of the trust corpus. But see Infra. 918. A. Losses from operation of business. 908. Any loss sustained in the operation of a business owned by the trust has been held to fall on principal, i.e., such losses are not carried forward into any other year in determining profits or income, but see Supra. 858. In Re-Estate of Davis, 54 Misc. 2D 1065 1967. B. Taxes. Assessments. 909. Ordinary property taxes are charged to the income account. 1. Assessments for permanent improvements. 910. However, assessments for capital or permanent improvements are generally handled as follows. Usually, the entire assessment is charged to the principal account. Under appropriate circumstances, the income account thereafter may be charged with depreciation or amortization of the amount involved. The 1997 Act allocates expenditures related to environmental problems to principal. 1997 Act 502-7. 2. Permanent. 911. Of course, the big problem lies in determining when a relatively long-term improvement is a permanent improvement. It has often been treated essentially as a question of fact or judgment. But generally, if the benefit is one that is likely to last until the remainder beneficiaries come into possession, it is considered permanent. With amortization, the handling need not be so arbitrary. See Upkeep. 912. Current repairs, maintenance expenses, and assessments for temporary improvements are chargeable entirely to the income account. Rest. 2D 233 CMT. E. 1962 Act 13A. 1997 Act 5013. 4. 1. Insurance. 913. In many states, premiums for insuring trust property are also chargeable to income, but other states call for apportionment because principal is protected as well as income, probably reflecting income bias. See Supra. 854. 2. Initial costs. 914. However, when a trust is initially established, the cost of putting trust property into rentable or income-producing condition is chargeable against principal, even though the expenditure is of a type that would subsequently be a repair and maintenance item chargeable against income. Rest. 2D 233 CMT. I. AM. Swarthout. Annotation. Rights and duties of life tenant and remainderman income and corpus with respect to repairs and improvements. 175 ALR. 1 in 450 1948. 3. Distinguish capital involvements 915. Long-term, substantial improvements are treated and defined see supra. 910 differently in different states. Some apportion between income and principal based on the life beneficiary's life expectancy or other supposedly appropriate basis. Others charge these expenditures initially to the principal account and then depreciate C infra 921, and others simply charge to principal. D. Mortgage payments 916. Interest on a mortgage debt secured by trust property is charged against income, whereas the principal element of each mortgage payment is charged to principal. Ellis v. King, 83 NE2D 367 IL. 1949. E. Trustees and attorneys' fees and other administrative expenses. 1. Income charged by some 917. Some of the earlier cases charged the trustees' compensation and related administration expenses entirely to the income account, at least in the absence of special justification for contrary treatment. PVS. Annotation. Trustees' compensation as payable from income or corpus. 117 ALR. 1 in 154 1938 premiums on a trustee's bond are still generally held chargeable entirely to the income account. AM. Swarthout. Annotation. Expenses of trust administration, such as court costs, costs of litigation, bond premiums, attorneys' fees, etc., as payable from income or corpus. 124 ALR. 1 in 183 1940. 2. Generally today apportionment 918. Such administrative expenses, however, including the fees that are payable to the trustee and to attorneys for their services, and usually also costs of accounting and judicial proceedings, are now generally apportioned equitably between the income beneficiary and remainder beneficiary. Rest. 2D 233 CMT. H. A. Discretionary apportionment 919. In many jurisdictions, the amount that each interest must bear is within the reasonable discretion of the TRNST subject to view by the court and varies with the circumstances of each case, e.g., nature of services rendered, whether services benefited one interest rather than others, values of respective interests, etc. B. Presumptively equal apportionment 920. In many states, however often by statute, such expenses are split equally between the income and capital accounts in the absence of a showing of special circumstances. F. Reserves for depreciation 921. Considerable litigation has centered on whether the trustee may pay the income beneficiary the earnings from depreciable income producing property, e.g., commercial real estate, without setting up reserves for depreciation to protect the interests of remainder beneficiaries. 1. Special Provisions 922. Of course, any explicit instructions by the settlor will be given effect. 2. Instrument Silent 923. Where the trust instrument is silent, there is a split of case authority and considerable diversity among statutes. A. Traditional View 924. Some cases have held that a trustee may not deduct for depreciation unless the trust instrument expressly requires it, i.e., that the burden of deterioration and shrinkage in value falls entirely on the remainder beneficiaries. See, e.g., Evans v. Uckerschassen, 100 F2D 695 DC. Sir, 1938. 1. Note. Some of these states only require depreciation to be charged with respect to properties purchased by the trustee, but not on depreciable assets originally transferred to the trustee by the settlor. B. Another View 925. In some states, by decision or statute, the matter is left to the sound discretion of the trustee whether to set up depreciation reserves and deduct for depreciation against the income account. C. Possible Majority View 926. The majority view today may be that depreciation reserves are mandatory under at least some circumstances. It is presumed in either all or some circumstances depending on the state that the settlor intended to preserve the corpus intact for the remainder beneficiaries. Thus, if the trustee holds depreciable assets and pays out current income without deducting for depreciation when required, she is personally liable to the remainder beneficiaries. 1962 Act 13A2 requiring depreciation to be taken on all property but that which is used by a beneficiary as a residence. But see 1997 Act 503B leaves the matter to the trustee's discretion, as in B above.